Okay, folks, as we get started here, I'll introduce our next speaker. But a few folks have asked about the handouts. If you pre-registered on Eventbrite, the email address that you used to pre-register should have gotten an email a couple of days ago. Corinna, was that yesterday? That has a link to the electronic handouts. So check that email, check your spam filter. If you haven't gotten those, just jot down your name and email address, and you can hand it to me or to Corinna, who's sitting here, and we will make sure we email the link to those handouts to you. Question? It would come from Eventbrite, I think. Yeah. Is that right, Corinna? Because it would either be Widener or Eventbrite. It was Widener? Okay. Yeah, if you want to check your spam filters. Okay, this next session is going to be sort of a combination panel, but presentation. We're going to start with Don DeRemus, who I'll introduce here in a second, and then Stephen, Matt, and I will jump in and talk about some of the federal legislation that's recently been enacted. But Don is going to start off by talking about the state landscape. And not currently in the room, but here with us today is also the Executive Director of the Senate Emergency Preparedness and Veterans Affairs Committee. Did I get that right? I reversed it, but you get the idea. Nathan Silcox, who has been a past presenter at this symposium, and he's Executive Director of that legislative committee, is also here, though snuck out strategically, so we may point to him as well to fill in any observations he may have. First, let me introduce Don. He is a certified paramedic, tactical medic, and serves in senior leadership as the Quality Assurance Manager and Government Relations Liaison for Suburban EMS out in the Lehigh Valley. Together with the EMS agency medical director, Don oversees patient care and CQI and also serves as the compliance and privacy officer. Don also interacts, educates, and engages local, state, and federal government representatives to the betterment of the organization and the EMS industry. With over 50 years, Mr. Dino, 45 in EMS. He draws on a vast knowledge from EMS, tactical EMS, firefighting, disaster response, and emergency management. Don serves on multiple statewide boards, served on the state commissions, and participated with the group in drafting of the current EMS statute and regulations. Don has spent 30 years with the Ambulance Association of Pennsylvania, educating policymakers and regulators through the participation in the drafting and amending of legislation and regulations impacting EMS and public safety. He has also authored and provided testimony before multiple State House and Senate committees. And I will just say with editorial comment here that I think we have experienced a period of unprecedented legislative success in Pennsylvania. And you guys have heard in past years from Heather Harris, who is the Executive Director of the Ambulance Association. I would say the other person who is as responsible for those legislative successes is Don DeRemus. And I think it is appropriate to give Don that recognition and credit for his role in Pennsylvania's legislative successes. So please welcome Don DeRemus.
You can also blame me for everything that went wrong, too. So I started on this journey 30 years ago when I became a director of a service, and it was thrust on the board of the Ambulance Association of Pennsylvania, where we got involved in legislative activities and eventually became the legislative chair, and I've pretty much been either a co-chair or legislative chair of the association for those 30 years with one of my mentors and friends, Charles Cressy, from the lowly paramedic from Punxsutawney, Pennsylvania. But when I started in the association, we used to get bills, read them, and then react on them. And we decided to change the whole process where we got in the front of writing bills, getting legislators to see our point of view, so we wouldn't have to amend things on the backside. It was a lot easier and a much better procedure. So right now we're in the legislation runs for 2 consecutive sessions. So there's 2-year session. We're in the last half of this 2025-26 session. So everything that needs to get worked on needs to be probably passed by June, or it's probably going to die. And then we start the cycle over again. So anything that's in the hopper now isn't passed or worked on gets dumped and readmitted the next year. Legislative tracking is not just about the ambulance. Right now, I'm tracking 67 different categories of bills and over 200 pieces of legislation. And these are some of the things we're tracking. So we always track the budget because that's where the funding comes from, which the budget was a disaster this year. We didn't know at one time we had a ton of money from the governor's budget in MSOP funding for the system. That disappeared between chambers 2 or 3 times and finally was put back in on the final thing. So the EMS MSOP funding got an extra $6 million this year to be spread out to the regions, and he's going to do some funding, special funding with that $6 million. Business is always an issue. Medical marijuana is a big issue right now, either medical marijuana, and there's a big push right now to legalize marijuana in Pennsylvania. Look at that twofold from a business perspective and a public safety aspect. You may have people driving that want to partake in legalized marijuana. You might have people driving your ambulance that use medical marijuana. There's case law is really bad on that right now, so I know the lawyers in the room probably don't like that topic because they have to do a lot of research to figure out where to go and what advice to give. Minimum wage was an issue. We didn't know how it would impact some of our rural providers. There was minimum wage bills up to 15 plus an hour. Pulse, we've been dealing with Pulse forever. PTSI, we've been doing very good on. And other things, but these are the areas, we look at all these areas because they all affect the ambulance industry in some aspect. There's also a big push for a state False Claims Act bill that's similar to the federal False Claims Act. The association every year breaks down their agenda, what we work on, what bills we try and push based on specific topics. And the main topics of our goal is workforce sustainable funding and reimbursement. You cannot bombard a legislator with multiple amounts of bills. You can't say, I want these 15 things done this year, because it just doesn't work that way. You have to prioritize what you want to work on and go from there. So there's a ton of bills under these things. I picked out some of the most prevalent ones that need to be worked on. House Bill 73 is Marty Kauser's bill. It deals with recertification to get the providers in early. They're trying to, right now the law's 2 years, but they want to push out to 6 years and get people to come back into the system that have expired for greater than 6 years. Also wants to do away with the CEU component of EMSVO training. When we were on the state doing the EMS Act revision, certain parts of the state, when we brought up emergency medical services vehicle operator training and certification, people lost their minds because they want somebody to drive the ambulance and they didn't think they had to have some certification. Back then it was just basically you had to have some kind of EVOC training and then you followed through on that and that was your certification. This will remove the CEU requirement from EMSVO and probably make it more palatable because you would just attach the EVOC training to the EMSVO. And the ambulance staffing flexibility, there's been some pilot projects that were tried in northeast Pennsylvania with ALS staffing, where there was providers available to respond to calls, but they didn't have a minimum staffed crew for an ALS service, and they wanted to bring that minimum staffing level down to certain exceptions, and that's what his bill would do. And you see that's still referred to the House committee. That's a bad sign because that means the bill's been out there for almost, well, he introduced that in 24 and it hasn't come out of the committee yet. So we have to work with the chairman to get that bill out of committee so it can start the process of getting to the floor and being voted on. Same thing with this bill, still referred in committee, House Bill 996. This will reduce and get rid of the sunset date for Act 72 at 22, which is the BLS minimum staffing level in Pennsylvania. Originally was 2 EMTs minimum, now is basically an EMSVO and an EMT. That sunsets in 29, or 27, April 29th to 27. This bill would eliminate the sunset, make that a permanent statute. On the sustainable funding side, there's a ton of bills out there for increasing the fire tax and the EMS tax. One of the options that municipalities have in Pennsylvania, townships, boroughs, cities, they can institute a millage tax for fire and EMS support. Right now, EMS tax is at 5.5 mils. They want to increase it to 5 mils. This is the bill that's the vehicle for that. They're using a test case right now with a second-class township code, which this is, and they're going to raise that millage to 5 mils, and the fire tax will go to 10 mils. The issue with this, in 25, there was an omnibus amendment that raised the millage in southeastern Pennsylvania. I think maybe it was 24, but it raised the millage in the collar counties of southeastern Pennsylvania to the 5 mils. It wasn't to do the whole state at one time. Since that's been passed, nobody's raised that millage to that rate. So you've given the municipalities a tool, but they don't want to use it because they don't like raising taxes. Another sustainable funding method is county authorities. So currently in Pennsylvania, municipalities have the authority to provide fire and EMS under the code bills from 2008. The county has no authority to provide those services. And what this bill would do would give the ability to counties to create public safety authorities. The thought there is, especially in rural counties, there's not enough municipal tax base or real estate tax base to provide services through a municipality. So they want to spread it out over a larger geographic area, and the county is the most appropriate thing to do that with. This is kind of based on the municipal authority model, which already exists in Pennsylvania, and there's, Gary, 9 municipal authorities now in Pennsylvania that run, which are basically ambulance services that collect a fee annually from their designated response areas. This has made it through the House, which is a good sign. It's in the Senate now, sitting on first consideration, so when they come back, hopefully they'll start picking this up. Not a lot of session days in the first part of the year because they don't have a lot to do, and majority of this time right now is going to be spent on budget again. It's like we just passed the budget, and budget hearings are going to resume in February. That's usually what their time's taken up in the beginning of the year. Our big bill, our big ask is House Bill 1152, which we've been working with Representative Cooper from the Southwest and Representative Borowski from the Delco region. What this does would mirror what other states are doing across the country. Would provide reimbursement for statewide, essentially a statewide fee schedule, 350% of Medicare. It also prohibit us from balanced billing. So we're trying to solve the balanced billing, surprise balanced billing side, as well as getting a higher reimbursement rate. And we're trying to slip in there some kind of patient protection where it's something that came out of the federal recommendations. Was it GAPAC? I can't never say that acronym. GAPAC? Where they don't want the patient to be responsible for any more than 10% or $100 for a balanced bill. Believe it or not, the insurers are against that. The insurers are against all these, but we've had meetings with them most of the summer and the spring, and they're just trying to run the clock out on us. But there is a lot of movement right now with the chairman that's on the vet committee, reaching out to other states that have passed these laws and finding out what they have done, and he's also meeting with the insurers from other states. TIP, treatment place. We're trying to follow the national acronym at the state. We refer to it here as Treat No Transport. We had a Treat No Transport law. It was signed, it was passed. The problem with the Treat No Transport law is the insurers are deciding what to pay us based on no formula. So we can get paid for Treat No Transport using AO 998, but what we're getting is what they decide to give us. So theoretically, based on the national fee schedule, you should get the base rate payment because that's what a base rate is. It's your services. But you'll see anywhere from payments from 75 to D max, you base rate or less. And what this bill would do, this is another Marty Kauser bill. Marty Kauser is one of our champions in the state legislature. He's from Northwest Pennsylvania in the hinterlands. What this would do would basically have medical assistants pay the highest of the Medicare rates published in the ambulance fee schedule, which is what he did with the medical assistance payments 2 years ago that we got codified in the fiscal code to get us a medical assistance increase, which is pretty good in Pennsylvania. And then there's Katie Muth bill. We've been fighting with the direct pay issue. There's been some litigation on the direct pay issue. There's been some congenial discussions with the Attorney General's office on direct pay issues, thanks to PWW on that. But what this bill was do is simply gut it and make it direct pay with no other stipulations. In my opinion, there's been some personal leeway given to statutory construction in some of these bills where interpretations have been taken out of context, but I'll leave that to the lawyers. Transformation, I was trying to bridge the transformation discussion this whole day was about. We need to set ourselves up for alternatives and destinations in Pennsylvania. The Department of Health has been a little lenient on the definition of facilities in the current EMS Act, but depending on who the director is or who the legal counsel is, that could change tomorrow. So we really have to work on the alternative destinations. We're actually working with Frank Ferry's office right now on a couple different things, and one of them will be to try and expand that definition. In addition to that, there's a current regulation right now, proposed final form regulation sitting in IRC that deals with mental health crisis centers. And I know UPMC is doing a pilot project locally where they're taking behavioral patients directly to this crisis center. That's what that regulation is going to deal with. But we need to, most of our laws do not allow us to get reimbursed for these alternative destinations, and that's what we have to work on, is codifying them and making them reimbursable. Community paramedicine, we've been messing around with community paramedicine since, oh my God, since the Rendell administration. Currently, the way the law is written, the EMS Act, there's only two definitions for EMS in the Act. One of them is 911 emergency transportation, and the other one is non-emergency transportation. So theoretically, you really can't throw community paramedicine in the current EMS Act. You probably have to change the definition of EMS to allow that. And right now, with the implementation of programs across the state, there's some very mature community paramedicine programs, and they've all been done under the Medical Practices Act, which gives them a lot more leeway. So it's going to behoove us as an association to get those groups together and decide what's the best avenue for them to maintain their current programs and move further, additional programs further, whether we just leave it with the Medical Practices Act or we actually create a community paramedicine statute under the EMS Act. Telehealth was passed last year. There is actually a telehealth law in Pennsylvania for reimbursement. We tried to get in there as defined as EMS, but we essentially fall under the definition of healthcare provider and healthcare services. So in theory, telehealth should be covered for EMS as a reimbursable event. And this is very important now because the Rural Health Transformation Project is out. Pennsylvania got awarded over $1 million, and that's going to rural Pennsylvania. And one of the things is community paramedicine in that. And telehealth is a part of community paramedicine. County 911 PSAP dispatch protocol. Right now, there's a group working on, what would you say that, Doug? Duty to respond, correct. So currently in Pennsylvania, the way our regulations are written, An ambulance that's dispatched by a public safety answer reporter or 911 center must respond. We have no right to turn down that dispatch. And that doesn't matter if it's 2 counties away. We have to respond by law. We're trying to come up with some kind of, it's actually being possibly going to be litigated in Pennsylvania. Depends on how this group works and how far we get. But we need to give the ambulance companies some leeway or some ability to refuse some of these calls, especially when it's taking them out of their own primary response area for significant amounts of time. Intermediate ALS dispatch. So intermediate ALS is kind of new in Pennsylvania. Was signed into law in 2009 under the current EMS Act. When they created the AMTs, the first thing we did was reached out to Medicare to make sure that the definition of AMT in our law would be reimbursed as an ALS service, and we got a letter back saying it was. So it's an ALS reimbursable procedure. The problem with ALS dispatch is currently in Pennsylvania, unless a county builds their own protocol, there's no framework across the state to dispatch an ALS service. So we have to come up with some kind of ILS dispatch protocols to help alleviate the need of paramedics for the minor calls that they can handle. And we're also looking at moving our current bureau director in the Department of Health either to an EMS commissioner or some other higher level function of a director or EMS commissioner. Currently, we don't think we have the parity with the fire commissioner's office. The fire commissioner's office has a direct line to the governor. The current bureau director has to go through the deputy secretary of health up to the secretary of health. And we're also looking at, of course, EMS Act revisions. The act is now 16 years old, 17 years old. And the regulations they were 2014, so they're old as well. So fortunately, our industry is very technologically advanced and changes frequently, and we probably should be looking at act revisions because anything in Harrisburg takes 2, 3, 4 years to get done. And if we don't start working on it now, it won't happen. Some of our legislative successes in the last 2 years, Act 15 of 23 was the greatest one. That's the medical assistance increase. It created a tremendous amount of revenue for especially first-class cities like Philadelphia and Pittsburgh, because at the time, they weren't getting reimbursed for any mileage. So essentially, you had to go 20 miles in the ambulance, with the patient before you could get reimbursed for mileage. After 20 miles, you would finally get reimbursed for mileage. It's kind of strange that you would have somebody in your ambulance and you'd have to like a taximeter running, and then you hit 20 miles and, oh, I can finally bill now. So cities like Philadelphia, some of the transports in my area, we rarely hit 20 miles. So we're finally getting paid full mileage for medical assistance, plus a decent amount of money, pretty consistent with Medicare. So I mentioned the telehealth bill, that's Act 42 of 24. Workers' comp coverage for PTSI, big win. That was pretty much promoted by Representative Mara, whose personal story is very sad, where her father was a Philadelphia firefighter and actually committed suicide. She drove this bill along with Senator Bartolotta, and we finally got this passed. There's a great concern that, similar to the cancer presumption on the fire side, that adding this to workers' comp is going to outrageously increase our premiums, but we've looked at other data from Florida and other states that have PTSI legislation, and it really hasn't increased it dramatically. And this is explained essentially as providers with PTSI, you want to get them into treatment before they become disability. And that was the whole hope of this act. This bill finally is now law, at a long implementation date of a year. Local EMS tax flexibility. Nate will appreciate this. This is one of the fastest turnarounds on a piece of legislation I've seen ever in Harrisburg. This thing went through in 6 months. And all it did was, in the current EMS tax, you can only use 50% of your EMS tax for wages and benefits. This gave the municipality flexibility to pass a resolution to pick any rate they want. So they could actually use 100% of their EMS tax for wages and benefits. But the turnaround in this bill was amazing. Act 18, Senator Mastriano's bill, added EMS to the overdose incident reporting network. We had a little debate with him about that because we already report all this overdose information into our current reporting system in biospatial and at the state. So the state is going to pull that data directly from our trip sheets into Odin to satisfy this statute. And I said the current budget, Act 1A of 2025, did give a $6 million increase to MSOF. The director had a meeting, basically a town hall last week, where he was discussing with people from across the state on how to spend the $6 million. It's probably going to, Steve, you think it's going to go down to the EMS councils to decide and then come together as a group? Thank you. Okay, so thank you. And I left out one law that was passed that I forgot about. Can't find it. I think it was Act 34 of 2025, which was under the Pharmacy Act. There's only certain providers that can dispense medication, and through the years, we've started doing naloxone leave-behind programs, and especially in Pittsburgh, that's where it first started, but it's kind of spread across the state. What that act did was codify in the Pharmacy Act that EMS can do these naloxone leave-behind programs legally. We're not dispensing. It gave us the ability to leave behind a dose of naloxone with a family member or somebody that's an extremist, so they can have a benefit if they would overdose in the future. And a new bill that just hit yesterday, House Bill 2134, is another rehash of the EMS Fire Grant Program. We will have to look at that as far as the association goes, but currently they want to increase amounts to the grant program, and on the EMS side, they want to take it from the fire commissioner and give it to the bureau director to function, to hand out that money. And they're pulling $8.1 million from the Pennsylvania tax rebate program to add additional funding, because they're going to add QRS as far as a compensable grant per person. I said that's only a handful of bills. Like I said, we're tracking over 200.
Yeah, thank you, Don. Steve and Matt are going to come down, and we're going to transition over to federal. I just want to follow up on a couple of things that Don touched on, just to close the loop on that. One was the reference to the Attorney General's position on balance billing in Pennsylvania by ambulance services. And as some of you in the room know, and some of you are party to some of these cases, the Attorney General originally threatened to bring legal action against a number of ambulance services in the Commonwealth, asserting that the direct pay law that Don was talking about was a balance billing prohibition. The statute, pretty clearly in our view, does not speak to prohibiting balance billing unless the ambulance service registers for direct payment under the law. Maybe 2 ambulance services ever registered for that, so it's not that type of balance billing prohibition. And we had the prior Attorney General here last year at this symposium. There has since been a change in the Attorney General's office in Pennsylvania. Widener alum Dave Sunday is now currently the Attorney General. We have met with his staff since that office has changed over. And the answer is, we haven't heard anything, as the ambulance services that are part of this case know. And no news is good news, because it shows me that they do not have an appetite to push this toward litigation. Our clients refused to enter into a settlement with the Attorney General's office. The next move was, if you don't like it, Attorney General, sue us. But prohibiting balance billing without having a rate established on what insurers have to pay for ambulance services is not workable. So the ambulance companies were not willing to settle, and the Attorney General ended up seeming not to have the political desire to bring suit against those ambulance companies. So everybody likes a nice, tidy resolution where like a court has ruled that the Attorney General's interpretation was wrong. We don't have that, but what we do have is the Attorney General's office that has not seemed to have had an appetite to bring those cases after having threatened that litigation, and we seem to have been able to repel that, at least for the time being. I would agree with your characterization that the discussions have been cordial with the Attorney General's office, as always, but I think we have prevailed upon them that their theory is not sustainable, since we're talking about sustainability. The other thing Don referred to is the work group that we have in Pennsylvania on the duty to respond. Don mentioned that some ambulance services are being dispatched well out of their coverage area. And I just want to clarify that I don't think ambulance services have a problem responding to emergencies. It's what we do. Nobody is saying, I don't want to go. But what's happening is, if the Commonwealth digs in on some language in the regulation forcing ambulance services to respond whenever dispatched, what we're going to have is what we do have to an extent, is townships, boroughs, and municipalities simply calling up we've already talked about the county solicitors who advise the 911 center directors. That's a whole cycle of chicken shit, right, to use Matt's term from earlier. And if the municipalities tell the dispatch centers to dispatch whoever they want, and the Department of Health says you have a duty to respond, they don't have to pay you, they don't have to subsidize you, they don't have to support your operations in those distant municipalities. But if this duty to respond is imposed, it takes away the ability for ambulance services to negotiate with those municipalities for fair compensation to go into those areas, right? So it's not that we don't want to respond, it's just that we do not want a one-sided mandated response without the municipalities having to come to the table to negotiate some form of subsidy to support the services in those areas. So, and that it's a tough situation, but that's the issue we're trying to thread the needle. And I have to give credit to the Department of Health and the state EMS director and their leadership for engaging a work group on looking for solutions to try to solve that. And I'm very happy to be a part of that. So thank you, Don. Feel free to hang out up here if you'd like. We are now going to move to the federal piece of this, and I'm going to sort of walk us through some death by PowerPoint. Matt and Steve are going to jump in and add some commentary here. Really, the first thing is the One Big Beautiful Bill Act, OBA, HR1, whatever you want to call it. And this is a massive bill, I think, as we all know. But we have sort of looked at it for specific impact on EMS and sustainability, which is the issues we're talking here today. The primary, I think, impacts of OBA are going to be changes to the ambulance payer mix. And of course, money drives deployment, money drives innovation. This is going to have direct impact across all the four major categories of an ambulance service payer mix: Medicare, Medicaid, self-pay, and commercial. So this is a recent New York Times article. This is in the handouts. The QR code is there. This is an unprecedented level of healthcare spending reductions. And there's some workforce impacts that Steve can talk about. But I think a lot of folks know that the implementation and the effective dates of provisions of OBA are taking effect in a staggered way. This is not uncommon. Legislatures, particularly federal legislation, likes to give out nice benefits before an election and then bring the pain after the next election. This is an age-old legislative tactic, and we are seeing this under OBA as well. So many of the things that people like are taking effect sooner, and some of these major cuts are going to take effect a little bit later. Always remember that some of this is still in flux, because even though this law has been passed, there are still efforts to try to change some of these provisions of OBA before some of the more negative impacts take effect. Starting with Medicare, one of the things we were concerned about, Matt, do you want to talk about SPAGO?
Sure. So SPAGO is a mandatory reduction in federal spending when the federal government passes a bill or passes a budget that adds to the deficit. Thankfully, after much yin and yang back and forth, it looks like the way that they have manipulated the basis for the federal budget to accommodate OB3 or OBA, it will not trigger PAYGO. So that's the bottom line, is at least we won't get that mandatory 4% Medicare cut, but everything's in flux.
Well, let's talk about Medicaid. This is obviously the biggest impact for OB3. And first of all, I think the OBA changes to Medicaid, you've read about in articles and commentary. This is a big issue, of course. The main ways that it's going to change the payer mix and potentially impact EMS sustainability are the main ones listed here. States implementing work requirements for Medicaid enrollment and eligibility. They will be required to more frequently do eligibility determinations as people's economic circumstances change and they may lose eligibility for Medicaid. That determination will have to be more frequent. There will be reductions in who's eligible. We will see a rollback of some of the ACA expansion of Medicaid. And this is a little bit in the weeds, but there's currently a 90-day retroactive eligibility period when people go on to Medicaid that providers have come to depend on. That will go down to 30 days. And you can see the eligibility dates are staggered, as I mentioned. There's some exception to the work requirements based on demographics. But one other thing we're seeing is that some states, you might recall when I referred to ACA expansion, under the Affordable Care Act, states were given incentives to expand Medicaid eligibility to those individuals up to 133% of the federal poverty line. The majority of states implemented the Medicaid expansions. Some states, however, and that was based on the fact that the feds were going to pay most of that expansion cost. Some states said, okay, that's great, but we've seen this movie before, and if the feds reduce their investment, then there's automatic triggers in our expansion laws to snap back to the pre-expansion eligibility, basically eliminate that ACA expansion tier if the feds reduce funding. That's exactly what's happening under OBA, and therefore some of these state automatic trigger laws basically reversing the ACA expansion populations will kick in with those federal funding reductions. Matt, anything to add on that?
The only comment is, even though Medicaid is a terrible payer, they're better than self-pay. So,
You're a glass half full kind of guy. So another thing that will change the payer equations here is that OBA is also imposing a requirement for states to impose cost sharing, co-payments basically, on Medicaid covered services. And this will start in 2028 unless legislation blocks it. And this is essentially a co-payment of 35% or 5% of income. And let's face it, folks, if self-pay is the smallest part of your payer mix, if you take the self-pay population who are also on Medicaid, how's that part of your payer mix looking, right? Basically zero. And that means that that self-insured co-insurance portion will basically be non-covered, right? You will, for most patients, not get. So that's really a $35 reduction in your Medicaid reimbursement, if you think about it statistically. Anything to add?
oh yeah, no.
I was just going to add, if you look at some of these provisions, look at the dates, okay? A lot of this stuff was designed to get through the next election cycle. This one doesn't go into place till 2028. Some of the other provisions aren't going in until 26, the work requirements, and a lot of them are phased in. So glass half full, this could change if Congress changes.
For sure. Matt, here, in fact, I'm going to even hand you the clicker for this section.
All right. No, you,
Take it,
please
take it,
control.
take it,
No.
take it.
Just know that if, and Pennsylvania is not a GEMT state, but there are folks that are online or perhaps here that do rely on GEMT. As you saw in our last financial index, the impact of GEMT is to raise the Medicaid reimbursement closer to your cost of providing service. GEMT has been in the hot seat for several years now. It is such a dynamic process. Just know that if you're getting GEMT reimbursement today, keep a very close eye on what CMS, specifically the Centers for Medicaid, does with your renewal of state plan amendments. We've seen in some states renewals of plan amendments looking much different than they were applied for, and really start thinking about what would your financial modeling look like if GEMT were either to go away altogether or be capped at the Medicare allowable in your MAC region. Those are two very, very possible, plausible outcomes from this process.
So just to bring terminology into the masses here, a couple of things. GEMT stands for Ground Emergency Medical Transport. What this is basically is a supplemental Medicaid funding program that some states have put into place. Again, not Pennsylvania. But what this basically is, some commentators have called it money laundering. Others have called it a shell game or a little bit of a process. I'll give you an example of how it works. In some states, I'll use California again, there's a program that applies for public sector EMS providers, so mostly fire-based, where the local contributions that a city, for example, spends on providing services through their fire department, and we know those are higher cost services, we know that from the federal cost study, they can use some of that expenditure that they're paying anyway for their city fire department as a Medicaid match, basically. And that justifies an increased federal match. What that means is a regular Medicaid fee-for-service provider might get $250 for a Medicaid-covered transport. In states that have these GEMT supplemental funding formulas, those public sector providers might get $1,100, $1,200, $1,500 per transport, where the same transport done by a private sector or nonprofit provider would get a fraction of that. So that differential in payment between public and private agencies has largely been a driver of EMS system choices that are being made in states like California, where more cities and counties, when they put out those RFPs for exclusive contracts, they look at the amount of revenue a provider can bring in. Obviously, that gives a significant advantage to public sector providers. And that's also given birth to, in some states, particularly in California, what is being called the alliance model, where these fire departments become the contractors in these systems, but they may not even have ambulances, and they subcontract with commercial or private companies to provide the ambulances and the staff, but it's the fire departments that send the bills out, right? So you can see why some of the people who are just not pro-Medicaid to begin with see the enormous expenditures in these supplemental programs and say, this is money laundering, it's a shell game, you're just moving money around. These public agencies aren't really providing the service, they're contracting it out, they're putting their name and provider number on the claims and getting 3, 4, 5, 6 times the amount of reimbursement for doing the same thing. So these programs have come under fire for those policy reasons. This is an EMS law and policy, symposium. But it's driving choices on what types of agencies are getting contracts in some of these systems.
And as Doug mentioned, the certified public expenditure portion is one model. There's another model which makes the money laundering even more stark, and that is that the providers, generally public providers, kick in money, just like hospitals do, because the GEMT program for ambulance services is an offshoot of a program that's been in place for decades for hospitals. And the providers kick in money, and then the state uses that money as leverage to draw down additional federal dollars from the federal government. The state then returns the provider's original money and the 60, 70, 80% FMAP that was drawn down from that initial investment. So that's why several very conservative think tanks have really called this money laundering, and that's really all it is.
Yeah, so these types of programs are covered in OB3, and this could have the result of substantial reductions in these supplemental Medicaid payment programs in states that have them. Now, let me circle this back to state legislation and some of the stuff Don was talking about. Every year I say this, and this is my opportunity to say it this year. A lot of the governing and a lot of the sustainability happens at the state level and the local level, of course, with local subsidies. A lot of this stuff is happening to us at the federal level. You've already heard about state advocacy improving Medicaid payments at the state level, right? This is why we join, support, and be active in state ambulance associations, because Medicare is our biggest payer, and that Medicare rates are, out of most of our control. But we can advocate successfully at the state level through efforts like what Don leads and what the Ambulance Association supports. That is where a key to the industry's sustainability may lie, and that is why the Ambulance Association is having such success at the state level, building relationships, advocating. I called you out earlier, Nate, when you were out of the room, but we have the executive director of the Senate Veterans Affairs and Emergency Preparedness Committee here. He has spoken here in the past. And having those relationships and building that kind of legislative success at the state level is now where a significant portion of the action is. And, earlier I said the Attorney General has a bad interpretation of balanced billing. We've advocated against that. True. Don mentioned legislation. We're not anti-balanced billing. It would be great to take patients out of the middle of billing disputes between providers and insurers, right? As long as the insurers have a legislative mandate to pay a sustainable rate to the ambulance services that provide the service, which is why if in Texas and in Indiana and in other states, New Hampshire, which is the kind of legislative blueprint that Don is talking about, if those insurers don't have a contract with the ambulance service, pay 350% of the Medicare rate or some objective number, great, and then we'll be happy not to send a bill to the patient, right? But without that payment benchmark, the Attorney General is trying to argue that you're prohibited from balanced billing without any assurance of what the insurance company has to pay. That's not workable. But getting the patients out of the middle of that is very workable, and I think our industry, by and large, would support that, because the time and effort it takes to bill patients for the return you get is really not fruitful. So make the insurers pay a sustainable rate. They're not on board with that, as Don said, but in many states, that has been the mechanism to ensure that we hold patients harmless, but pay the ambulance services a sustainable rate. By the way, before California did that, there was a study showed that everybody's like, premiums are going to skyrocket. It was like 1%, right? It was a very small amount of money when you look at what insurers spend on ambulance services across the board. They're going to raise premiums just because the day ends in Y, right? It's not ambulance services' fault. So, this is another argument that has to be made with objective data. Okay. Despite the OBA phased-in timeline, some states are already moving to reduce Medicaid coverage, Medicaid benefits, scope of services, payment rates, and that sort of thing, and we're already seeing that. Anything else, Matt, Steve, Don, anyone on state Medicaid impacts under OB3? You're shaking your head no, but you turned your mic on. So you've got. Okay,
Yeah.
Commercial insurance, go right ahead.
So we're seeing this play out. Our government shutdown that we all experienced in October was essentially over this particular issue in the Affordable Care Act exchange programs. And one of the things that, as Steve and Doug have mentioned already, they were phased in, delayed implementation all the way up to 2028, 2029. However, the loss of ACA subsidies to subsidize premiums for people who get insurance through the healthcare exchanges has gone into effect. And you'll see very quickly that some of your commercially insured patients are not going to be commercially insured. One of my good friends I was just talking to over the weekend, she always bought her insurance through the ACA exchange. Her premium went from $400 a month to $1,400 a month without the subsidy. She can't afford it, so now she's uninsured. That's going to happen to a lot of people in your community. So again, keep a close eye on what happens federally. I know that the House is trying to get some legislation passed that does something with the ACA subsidies. Senate, not really supportive of that, so we're in this deadlock. We're 2 weeks away from another potential federal shutdown, and it largely over this issue. So just keep a very close eye on it and model what that looks like for you guys.
Yeah. So as Steve, are you going to add anything? So as Matt mentioned, this was the driving issue behind the shutdown, and we are now seeing, as Matt said, in real time, the impact of the loss of those subsidies. There has still been some recent House votes and some activity on that, but it's still not gotten through the Senate, and probably is likely not to. So the expiration of these subsidies for marketplace premiums seems like it is now a dead part of the Affordable
Doug, can you
Care
go back
Act.
one slide
Yeah,
real
of
quick?
course.
I've noticed a pattern here with your QR codes.
Yeah.
Is that some reference to those of us on this panel?
No, the dinosaur. Google puts it there. I honestly have no idea. Please do not take it personally if you're 60 or older. Okay. So there's other limits on the ACA exchange enrollment, shorter enrollment window, loss of automatic re-enrollment, the tax subsidies as we've talked about. That has, as Matt said, already happened. And Matt charitably said that this will cause more self-insured payer mix. Let's call it what it is, uninsured, which is a very non-fruitful portion of the payer mix. So that last portion of self-pay or uninsured, we will see more people because of Medicaid reductions in eligibility and loss of commercial subsidized insurance premiums. More people go from one of those insured buckets into the uninsured, or charitably called self-pay bucket. And that's going to be certainly a revenue driver. Steve, do you want to talk about the workplace OB3 implications?
Yeah, there's actually some positive things in OB3, and those relate to the workplace. You might recall the big campaign promise of the president, no tax on overtime, no income tax on overtime. And everybody, whoa, that's great. That's going to cost zillions of dollars. Well, when push came to shove and the bill was signed into law July 4th, it wasn't quite no tax on overtime. It was a tax deduction that employees could take based on the premium portion of their overtime. That means the 1/2 of the time and a half, okay? So already you see a big chunk taken away there. But with respect to who's going to benefit from this new tax deduction for overtime, the careers that are most apt to benefit are public safety careers working many hours, okay? EMS, police, fire, and so forth. So, and there's other careers as well, but, a lot of your folks work a lot of overtime. And there hasn't been much attention to this, but it is a substantial benefit for employees. Some employees that work a lot of overtime may see, and it's an above-the-line thing, so it's going to have a direct impact on their tax burden, and they could see several $1,000s of savings based on this, depending on how much overtime that they work. Now, there's limitations on it, up to $12,500 per person, but if you file jointly, it's $25,000. It's also phased out a bit if you make over $150,000. Well, not a whole lot of EMS folks make over $150,000 unless you're part of a unionized fire department somewhere else. Or you're in California. In a few other states.
You guys said it.
There's some extensions, or exceptions, I should say. So there are some limitations on it. The White House actually put out a little calculator, too, that you can go to, and I'm not sure if that was in the handout or not, but it's easy to find. Scroll down to the bottom of that page that the White House has on the OBBA, OB3 workplace stuff related to overtime. So that's a pretty significant benefit. And it's going to be the responsibility of the employee to file this, put it on their income tax return for 2025. It's retroactive to January 1st, 2025. So that's a good thing. The bad part is just the record-keeping side of it, and how are employers going to put this on W-2 forms and so forth. And they're going to make changes. There's a proposed form now that the Department of Labor came out with, but they're giving us a free pass, giving employers basically a free pass for 2025. There's no penalties for not reporting it. Reasonable estimates can be given. The employee, it's really the employee's responsibility to, come up with the amount of that premium portion of the overtime, okay? So then for 2026, employers have an obligation to report this, and they're going to put that in a separate box, or they're going to explain how they're going to do that. It's in the process now. So that is something that could directly benefit employees. Now, some may say, well, gee, doesn't that encourage people to work a lot of overtime? I don't know. I think it's maybe, but, do you think people are going to want to work more overtime because they can get this tax break? I don't think so. I think some are going to say, hey, yeah, it doesn't hurt. But I don't know. You guys have to decide that, see what situation you're in there. So the one thing it could
But
do.
Steve, sorry, on that point,
Yeah.
what's the magic phrase from the Fair Labor Standards Act on the employer's obligation to pay for time
Worked.
suffered or permitted?
Suffered or permitted to work.
Required or
yeah.
permitted. So the employers have responsibility to make those schedules and, not let people just run wild on overtime.
That's right,
But
that you can set policies on when people can work. You don't want people staying over. We get into this question a lot with, people doing their patient care reports at the end of the shift and they stick around and all that. Yeah, you got to watch that because there could be more potential abuse of overtime practices by employees. And, you could have some competitiveness, questions about fairness, about how you divvy out overtime. I've heard that's an age-old problem, Why does so-and-so get all the overtime, Well, because they're friends with the supervisor, that kind of thing. So I think we'll see a little more of that. So that's something to be prepared for. There's a couple of other benefits on the workplace side, and I'm not going to get into the details of them. They deal with child care benefits for employees and tax breaks for employers that provide child care. It's pretty significant, actually, okay? And a few other benefits that are tucked away in there that, sort of have been, muted out because of the din of all the other, negativity about the bill. But there are some of those benefits as well. So that's a quick
you want to mention
summation.
I-9 compliance real quick?
Oh, my goodness. Thank you. Okay. The ICE budget, no surprise here, has been like quadrupled, okay? So you're going to see a lot more activity on immigration control enforcement and IRCA, the IRCA law. Immigration Reform Control Act, I forget the exact acronym, but that law has been around since the 1980s, okay? That requires every employer, regardless of your size, to verify the eligibility of employees to work in the United States. It's been there since the 80s, so it's no surprise here. And it's a pretty strict law. Within like 3 days, you got to verify the employee's identity, that they're eligible to work. There's an e-file system you can use to check, but you literally have to check in person, look at documents on their face, like social security card, passport, driver's license, things like that. And there's an I-9 form that has to be maintained by employers, okay, in the employee's file, every employee. And this is an area that has not been enforced very much in the last 20 years or so. And the penalties, it's typical of what like the HIPAA penalties used to be, Ryan. What were they like? Were they like, was it worth paying the penalty or just, continuing to violate, most, some places said, well, hell, we can only get dinged for $20,000, why not just pay it? Well, that's all changed. The penalties are thousands of dollars. I think they're like 20 or 30 times what they used to be in terms of penalties for not maintaining the I-9 forms and not verifying employees' eligibility to work in the United States. So number one, when you leave here, is one of the important, very important takeaways is go back and check and make sure you've got properly completed I-9 forms for all your employees. And if you don't, you should do that. Why? Because there will be thousands of new ICE agents who are looking for things to do, and there will be desk audits, and you could get a notice of one of these audits. and they will want you to provide and cough up verification that you have all this in the employee's files. And the penalties are severe now. So something that we didn't always pay close attention to on the HR side has now risen its head to the forefront, okay? So that's serious. And that's something that hasn't been a lot in the news either. I haven't seen a whole lot about that because, well, let's face it, the news focuses on, the stuff that looks, you can see visually on the news and on the video feeds and all that. And, a desk audit of an agent doing I-9 audits isn't the thing you're going to see on the 6 o'clock news. You're going to see the other terrible things and all that you were seeing. So anything I missed on that?
No, thank you for covering that.
Christy's out there. She's our employment law expert. Did I miss anything on the I-9 or any of the OBBA stuff? Just doing it off the top of my head. What's that? Okay, go ahead.
Mike is on the way.
Okay.
I-9s don't apply to volunteers, but
Good point.
my one caveat on that is there are two different kinds of volunteers. There's the Department of Labor's definition of a volunteer and the IRS's definition of a volunteer, and you never know which definition the Department of Homeland Security is going to use. So my suggestion on CYAing your organization is if you have true volunteers, perhaps get an I-9 anyway, just in case. Not that it's required, but the IRS's rule of who's an employee is if you pay them anything in cash or in kind and you have the right to control the manner and the means of what they're doing and how they're doing it, they're an employee and not a volunteer. So should the Department of Homeland Security use that for its measuring stick, the safest thing you can do to protect your organization is make sure everyone has the right to legally work at your organization, including the volunteers.
Yeah, I would say particularly if you're paying volunteer incentives and paying folks, per
Stipends.
call, all that stuff. There's a lot of gray area between, who's an employee and who's a volunteer, as Christy mentioned. I would say personally, if they're not getting any payments, I don't see the need for it. But if they are getting payments and more volunteer agencies are providing incentives, then you're getting into, that realm.
And then you've got to discern what's any payment, because if it's in kind, that means anything that's not cash, which could be just giving out free gear or something that you would consider de minimis, you'd never know what they're going to use against you. So the best protection you can have is to be ahead of what might be used against you and make sure that there's nothing there.
Good advice. Thank you. I want to go back to the overtime provisions of OB3 here for a second. Steve mentioned that the feds came out with kind of a grace period guidance that they will not be penalizing employers who did not separately report deduction eligible overtime in 2025 since it's retroactive, and employers are allowed to use reasonable means to estimate the overtime. Employers who can't track overtime are probably also not complying with the Fair Labor Standards Act, right? So, look, we compete for employees. It's a difficult workforce. Not difficult workforce, can be, but I mean a difficult time for workforce recruitment and retention. And if this helps your employees take advantage of a benefit that they have under the tax code, why wouldn't you want to do that for your employees? So this is an employee benefit that you want to collaborate with them on being able to take advantage of. So since A, you've got to have the records anyway for Fair Labor Standards Act compliance, and B, it helps your workforce differentiate yourself as an employer from a retention standpoint and make sure that you cooperate and go through your records and report that to make it as easy as possible for your workforce members to take advantage of what is one of course, the more well-received and positive aspects of OB3. So,
And like the other things, this one phases out too. It's good from January 1, 25 to, I believe, the end of 28. So, so it's a short-term benefit.
now I'm going to turn it to Matt here in a second. I don't want any of the commentary we're making about what we think is good and bad parts of OBA to be seen as political commentary. We're talking about the impact on sustainability for ambulance services. So we're being sort of quantitative rather than qualitative in those judgments. But one of the things that will add some resources into healthcare systems are the RHT transformation grants, rural health transformation grants. And this is not chump change. This is a lot of real money. And Matt has looked at the RHT grants. There was a pretty tight window. OB3 was passed in July. The grant applications were due in December, and the funding decisions have been made. So the feds are moving quickly and deliberately on this. And Matt has researched all of the RHT grants that are being awarded to the states. And EMS is prominently figured in some of these and will bring some resources into rural EMS transformation. So, Matt, with that,
Yeah, only commentary is that one of the great things that happened with this process is that on the RHT specifically, states got additional points if they included EMS transformation in their grant applications. So as a result, because it was a competitive process, at least part of it was a competitive process, they did include EMS in it. So go to the PWW Advisory Group webpage, website, and under resources, there's a summary where we've literally included state by state what that state applied for, what in many cases what they were awarded, and what the EMS portion of their transformation is going to be. Tremendous resource, and kudos to those states. There were only 6 states out of 50 that we could not find any specific reference to EMS, so the vast majority of states did make some reference to EMS in their grant applications, and some really cool programs. So have a look at those summaries.
And those are also really aligned with the EMS system transformation stuff that we've been talking about here all day.
Yeah, you'll notice some common themes: treatment in place, funding treatment in place programs, funding telehealth programs, funding alternate disposition programs, and funding a lot of mobile integrated healthcare programs. So have a good close look at those. We used those recently in a discussion that we had with CMMI. So good.
There's the fossilized QR code that will take you directly to the summary that Matt mentioned that he prepared on the RHT grants. And there are going to be future rounds of this funding, and these are really good templates and ideas. And this involves, there's one application from each state. So it's not like one comes from the EMS office and one comes from the Office of Rural Health and one comes from. So we have to be at the table with state stakeholders to make sure that EMS is included. But as Matt said, this was a prominent part of the RHT concept, and EMS has been included in a lot of these, which is great to see. And again, there will be future rounds of funding. So this is a document for sure worth taking a look at. And this is a link to CMS's announcement of the grant awards. On average, states are getting $200 million, some more, some less, but that's a not insignificant amount of money.
And it's $50 billion over 5 years, right? $10 billion a year. So for the next 4 years, it'll be additional.
And in the handouts, as Matt said, these are just a few of the snippets of what some of the states are doing. But there's a lot of EMS system transformational stuff exactly along the lines of what we've been talking about embedded in some of these state grant awards. So, and we have Pennsylvania's there as well. And you can see that they're looking at identifying partners in EMS initiatives and modernization. So good stuff there, and there's a few in there. Let me wrap up OBA before we move on in a few minutes we have left for this panel. Obviously, we talked about a mixed bag here, not politically, but from a sustainability standpoint. Some revenue is going to flow out under Medicaid and commercial insurance. Some may flow in through employee benefits and through rural health transformation money and some other things. Revenue, money drives innovation and services, so we will see changes. And we like to talk about what EMS can do in the light of some of these significant healthcare spending cuts. This is another reason why transformation is not optional, because as the government moves out of payment for a lot of these populations, we're not going to get paid for every low acuity response and transport and then 2 subsequent hours in the emergency department waiting to hand off care to hospital staff. If we can implement these modalities and treat these patients on scene, do telehealth, release them without transport, not only, we may not get reimbursed for all those modalities, but if we can avoid non-reimbursable costs, just that side of the ledger will help the systems become more sustainable, right? By the reduction in unsustainable or unreimbursed costs. So we have to economically model what are the impacts going to be with Medicaid reductions and a shift in payer mix from people who are commercially insured or Medicaid covered to uninsured. How is that payer mix shift going to impact our revenue? With those shifts, agencies are going to have to better leverage technology. Payer discovery, that stuff's going to change in real time, retroactive eligibility, using technological solutions to identify payers and coverage and eligibility in real time is crucial. Not only is this at the billing side when revenue cycle staff sit down to code and bill a claim, but this, I feel a little vindicated here, stuff we've been saying for years when we've trained EMS clinicians on documentation skills. We have always said, if it's critical, patient's non-responsive, they're non-communicative, they're under duress, don't be asking for their insurance card. But we know that is a small percentage of the cases. And when the time, instead of the medic or the EMT sitting there behind the patient's head on the squad chair doing, social media, ask the patient for a copy of their insurance card. Write the information down. Real-time payer discovery begins at the time of service. And we've all been in the street, on the street, in the field. We know that in the majority of cases, we can ask patients that if we just do it, if we're not too lazy to do it, right? That's where payer discovery will have to start in this fast-moving era of payer realignment. We can approve our non-emergency intake for the calls that we don't have a legal obligation to respond to, right? When facilities call us for these increasing numbers of interfacility transports that Steve was talking about, we can be determining questions like medical necessity and coverage before we put the key into the ambulance, and to right-size our response and transport services with the kinds of modalities we've been talking about. If we can reduce unnecessary volume, be available for clinically appropriate services with these alternative programs, that's how all of this fits in to sustainability. Hospitals are still getting penalized when their Medicare patients get readmitted within 30 days for preventable readmissions. Hospitals getting penalized has been a source of revenue for EMS agencies to fund mobile integrated healthcare programs where they go out and see these post-discharge patients in their homes and provide care and make sure the patients are adhering to treatment plans and keeping their prescriptions filled and visiting their doctors and doing those things. So that remains a source of funding. We're seeing in real time rural hospital closures, suburban hospital closures. Keith's here from Delaware County. That's been a significant impact. Your transport times are going up, right? The specialties and the services that hospitals can provide in certain, as Steve mentioned, are being reduced. More interfacility transports. More people, this is predictable, folks. This happened before Affordable Care Act. It will happen again. The more people who lack insurance will seek care from 911 and emergency departments. The amount of people seeking primary care for sniffles, stubbed toes, flu-like symptoms, and primary care will absolutely go up, and the impact on emergency departments and 911 systems will increase predictably when coverage is lost, because people know emergency departments have a legal duty to see them regardless of their ability to pay. So these are other impacts operationally we will see. Comments on any of that? Okay. Some other federal things. Matt mentioned that the government shutdown that happened in October. We are teed up for that to happen again. I don't think that there will be another shutdown because it was the ACA subsidies that led to that. I think the Democrats have decided that is not worth another government shutdown. So I don't think we're going to see them dig into the level that caused or that contributed to the shutdown in the fall. But those spending bills were only abridged till the end of this month, which means the Medicare add-on payments expire, the Medicare telehealth flexibilities expire, the Medicare hospital at home, acute care hospital at home flexibilities expire again, And all of that will depend either on a budget or a continuing resolution to continue to fund those. We are going to be right up against what we were up against in October as well. Comments on that? Okay. There's some other workforce legislation. The handouts talk about that. Lastly, and we're transitioning into sort of a wrap-up, so whether we go a few minutes after this, we'll still wrap up at 3 o'clock. Another interesting development we're keeping an eye on are some potential judicial signals that the key TAM provisions of the Federal False Claims Act might be looked at critically by the courts in the coming term. Don mentioned state legislation that would mirror the Federal False Claims Act. This has been, ambulance services are like less than 5% of all Medicare spending, less than 1% of Medicare Part B spending. But there seemed to be an outsized number of False Claim Act cases against ambulance companies alleging improper billing for medically unnecessary services and stuff like that. Most of those cases are brought by whistleblowers, maybe somebody who worked in the billing office or somebody who said, we're billing all these claims inappropriately, and they bring this whistleblower case and, of course, get a percentage of compensation of what's recovered. In a couple of recent cases, justices of the U.S. Supreme Court have mused out loud in dicta, what we call dicta, which is commentary, essentially, in either dissenting or concurring opinions in U.S. Supreme Court cases, that those whistleblower provisions of the Federal False Claims Act might be unconstitutional, despite the fact that those provisions have now been in effect for 162 or 63 years, okay? Abraham Lincoln signed the Federal False Claims Act into law to combat Civil War profiteering, and that provision for the whistleblower cases has been in the law since its original passage in 1863. So some of the language here that we've seen in these cases, Justice Kavanaugh in the case of Wisconsin Bell, cited here, said the Act's key TAM provisions raise substantial constitutional questions under Article 2. And Justice Thomas also in the Polanski case said, there are substantial arguments that the key TAM device is inconsistent with Article 2 and that private relators, that's the legal phrase for a whistleblower, may not represent the interest of the United States in litigation. In my view, the court should consider the competing arguments on the Article 2 issue in appropriate cases. Of course, the argument here is that curtails executive branch decision-making, prosecutorial discretion, to decide what cases to pursue on behalf of the United States. When a private party does that as a whistleblower or a relator, the constitutional argument you can see some of the court's justices raising is that that is a usurpation of Article 2 powers and therefore might not be constitutional. Interesting that it took 162 or 163 years to come to that conclusion, but then again, we have seen other precedents being upended by this court, right or wrong, however you feel about that. We're here in a law school, so I know people could see that both ways. But just putting that on everybody's radar, that is it open season for Medicare fraud? Well, the main source of these cases are whistleblowers, and if that's taken away, only the government will be able to bring these cases, and the government simply does not do it with near as much frequency as whistleblowers do. So that is an interesting development.
I guess you could say it's another case where payment policy impacts policy, right? Payment practice,
Yeah.
Because if you're not going to get treble damages and 25% of the treble damages, why blow the whistle?
And therefore, why be as attentive to your coding and billing and just bill things and get paid for them, right? So this will be an interesting time for compliance. Ryan, you really look like you want to say something. Okay. Waiting for yeah.
It's going to be interesting. Of course, this is coming from the conservative arm of the Supreme Court, these questions from these justices, but we also know the Supreme Court is, tilted more conservative today. So it'll be interesting to see what happens. But I would say, as Doug has cautioned, don't, underestimate the power of the federal government to bring cases, because the current administration, has said fraud and abuse is a major thing that they want to go after. They're doing it now with Medicaid, and we're seeing an uptick in audits and investigations on the Medicare side as well. So we're going to see more involvement of the government in these cases, and stepped up, especially if the key TAM whistleblower provision goes away. So I don't know. What are your odds on the thing going away? I'm not so sure it will.
I think it will.
You think it will?
Yeah.
We'll see. We're going to bet $100 on that.
All right, sounds good. We got a wager here,
See.
right here, right now. Don, anything to add on legislative stuff before we transition into the last closing session here? Okay, thank you. Nate, anything you want to weigh in on? Yeah, and thank you for your advocacy. I mentioned Nate Silcox when he was out of the room, but not only is he the executive director of the Senate committee with jurisdiction over these bills, but is a local elected official still, right? Oh, not quite. I apologize. Longtime township commissioner, and was a longtime township commissioner, very active in local government, sees the issues we've been talking about from a local coverage standpoint with all the municipal issues. And I can't tell you how fortunate we are to have somebody with that kind of insight working so collaboratively with the legislative folks at AAP
Being
on
a
those
life
issues.
member
So-
of the Hampton Fire Company, we are indebted to Nate for his support and the support of the commissioners there. It's a model situation in government, fire company, public safety cooperation. It really is.
Yeah, thank you for your steadfast advocacy, Nate. We really appreciate that. Okay, well, Don, thank you. And we're just now going to transition right into sort of closing thoughts. And, of course, any online questions on anything that we didn't get to throughout the day. So why don't we actually start with questions that folks may have on any of the stuff we've talked about, or even stuff we haven't, because we had such robust dialogue earlier. And then I'll turn to the panelists here for any closing thoughts they want to give before we wrap up. So let's start with the folks in the room here on any questions, comments that they'd like to add for the good of the order.
Actually, this question might be more towards Nate, but for you guys as well. With the treat no transport going into the Senate for vote, possible movement, what can we consider that the timeline would be for that movement of that bill?
Hang on, Nate. Mike's coming your way.
The other side of the room here. So we'll be introducing it, the Senate version, on Friday. So it'll get referred to committee. I'm assuming it goes to Health and Human Services Committee. Senator Mastriano, Senator Baker, Senator Baker are the prime sponsors of the co-primes on that one. We got about 9 other co-sponsors. So we're pretty pleased with where that's at on that front. But it'll likely go to Health and Human Services Committee, which is Senator Brooks's committee. Again, she's a co-prime on it. There's a likely that she's going to have a forum, whether it's a hearing or other aspect here before it moves. That's going to be an opportunity here for us for your organizations here to weigh in and support it. Obviously, there's the House version that's been stuck in House committee here for some time, but we're hoping that we just don't have this hearing, but then ultimately it'll lead to movement in the near future. So stay tuned on that one.
Thank you. Yeah, Don, please.
So, interestingly enough, sometimes a bill like this, like there's already a House bill with the same language in it, and they're going to introduce one in the Senate. It might not go through the complete bill process of 3 votes in the House, 3 votes in the Senate, and then the governor signs it. What Marty's done in the past is run this through the fiscal code at budget time and enacted through law by the fiscal code, which is how the medical assistance increase was done. So there's other avenues to take other than an actual bill passage through the House and the Senate.
And Doug, can I throw in 2 comments also?
Yeah, please.
That's what we did in Texas. So the governor's budget office liked the treatment in place reimbursement so much for Medicaid that they didn't want to run the risk of it timing out in the legislative session, so they just pulled it and put it into the what they call a rider for the budget, so that the Medicaid had to do it. However, keep in mind that if a state law gets passed that allows reimbursement for treatment in place, that only applies to state-regulated health plans, which is a very, very small percentage of your commercially insured population in most states. However, if you are not billing for treatment in place today, start doing it tomorrow. Because what the financial index has shown us is that 38%, nationally, 38% of the claims submitted for treatment in place are being reimbursed. So if you're not billing for it, start. Don't wait for state legislation, because there's nothing that prevents you from sending a bill for treatment in place today.
Good point. Other questions, comments from here in the room?
Yeah, I have a question. On the OBBBP, whatever that is, the three. Yeah, okay.
Oh, blah, 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 blah.
So, the Medicaid section affecting the GMT program. Currently in Pennsylvania, we actually have a code that's paying higher than the Medicare rate. Will that affect that rate, the changes in Medicaid? So our BLS non-emergency rate is actually higher than the Medicaid rate.
No, I don't think it will. I think what will happen, though, is that fewer enrollees, fewer eligibility, from an eligibility standpoint, the reduction in spending will be through reduced eligibility, not so much a payment cut to rates that are established through fee-for-service payment rates. Because we don't have a supplemental program, that piece of it's not at risk. So I don't think that should result in a reduction in the rates that you guys won legislatively, but fewer people will be eligible for coverage under that.
Same rate, fewer patients.
I'm just looking at the fact that majority of that budget comes from federal match, and whether the federal match will change, making DHS lower the rate.
I don't think so.
No, so you guys are sort of in a good position because you don't have GEMT. So because you don't have it, it's not at risk. You're good. Don't ask for one.
Other questions in the room? Yes, in the back.
The Senate Bill 737, in the discussion, it sounded like that had to be a countywide thing. Can that be does it have to be countywide, all the municipalities, or can it be a group of the municipalities within a county?
So currently, you can do multi-jurisdictional municipal authority by current statute under Title 53. You don't have to do a county thing. Two or more municipalities can go together and form a joint municipal authority.
We have a director of one of the original municipal authorities in the Commonwealth of Pennsylvania here with us, or a couple, I guess. Yeah. Gary, is there anything you'd like to add to that?
I was just talking with Nate. It's out on the floor waiting for the chair to put it for a vote. The original resistance to that was PSATs, which is the township supervisors, because there was a lot of restrictions to the townships, and they've eased that up to be a joint authority. So the nice part about that bill, even though, as Dawn said, you can create an authority now. The best provision of that bill is that it recognizes the authority can assess a fee for readiness, which is huge. Because that is the whole question of, is it legal to, because you've got to remember, authorities were originally created to service sewer and water to properties. Is a readiness fee challengeable in court? This would codify it and make it legal.
Thank you, Gary. Other questions from in the room? Corinna, were there any in the online that you recall?
There was
Okay.
one or two that I can.
Okay. Other questions or comments? Okay, so Steve, were there other issues you wanted to?
Yeah, just one or two that came online, quickly cover.
Okay,
Yeah.
go ahead.
Yeah, a couple of questions came in, when we were doing the workplace thing. One comment was that, well, EMT and paramedic programs don't teach this stuff. They don't teach communications, compassion, and so forth. And that's generally true. I think, again, what's happened is the national standard curriculum doesn't keep up with the times, okay? And as things change, that curriculum needs to change, and that's something you all as leaders can advocate for. But it does point to a greater responsibility for individual EMS services to do, more effective onboarding of people coming in and training all your supervisors and making sure everybody's on the same page. Historically, EMS agencies haven't done a lot of leadership and supervisory level training, group training and things of that sort. That's critically important, I think, to establish that culture that's necessary to, deal with these changes, because it's tough. And there's no doubt about it. A couple other comments came in, well, this is tough. EMTs and paramedics are getting burned out. What are we supposed to do? Well, we need to make sure as organizations that we provide the support and provide the programs for them to help with that, and that we're sensitive to some of these other issues that come into play, whether they be personal, workplace, or otherwise, and hopefully tighten up some of the operational things in the design things to make it better for them, in the sense that the paramedics are going to be seeing more patients that they were trained to see, so to speak. So all of this is really intertwined. It truly is. And it's going to involve, changing expectations, as we said, for the public and for our people, and putting some resources toward doing that. And I know that's going to cost money and so forth. But I tell you, a lot of it is just how you conduct yourself every day, walking around and talking with your people and being positive and emphasizing that, this is a pretty good darn career we're in here. What other job on the planet is there where you can actually change somebody's life in a matter of seconds? I can't think of any, So that kind of stuff is, I think, important, in the drudgery of all this and all the complexities that we talk about, is to be positive and to update our own onboarding and people policies in the organizations.
Cool. Okay, so let's turn to just some closing thoughts and go around to start.
That was it for me.
Okay, well, we'll start with Matt here to
Two
wrap
things.
up the whole theme of the day.
There's never a better time to make changes than during crisis. And I think everybody's already nodding their head. We are in a sort of perpetual state of crisis right now because we are slow to adapt to some of these changes. Use this opportunity. We often say, never let a crisis go unleveraged. And the best time to ask for change or to ask for permission to change is now, during this crisis. Second, and my father taught me this as a very young youngster, often it is much easier to gain forgiveness than permission. So if you know that there are evidence-based, defensible changes that you need to make in your system, do it. When we went to a tiered system in Fort Worth, we involved everybody in the process, and we went to the hospitals after 4 months and said, hey, how's the feedback been from the ER staff? And we had ER charge nurses, and if you've ever met naysayers, they are ER charge nurses. I know I was married to one once. That they say no to everything. And when we said, how's the tiered deployment, how have the BLS crews been receiving patients from the BLS crews? And honestly, the response from all 11 nurse managers in the ER was, you did what now? They didn't even notice the difference. And that's the ER staff. So be bold, leverage the crisis, seek forgiveness instead of permission, and move forward.
Nice summary. Steve, you want to add some other with
I'm
the
good.
whole thing?
Sorry.
No? Okay.
We're good.
Don, you have anything you want to chime in on?
Just keep abreast of what's going on in the state. Heather's very good at sending out call to actions, and if we send out call to actions, that means we need grassroots support, so your voice means a lot. The biggest thing you hear on the Hill is, I'm not hearing this from my constituents, and we don't know how that is, but we've gained great traction in the Commonwealth lately, especially with what's happened in Delco, is really a hot button issue with the Southeast, and that's big because half of leadership in the House is from the Southeast of Pennsylvania. yeah, so just keep abreast of what we're doing, and when we need, ask for your help, give us your help, and you should be out there already doing it yourself. And Gary wants to plug to everybody wants to be a member.
You need to become a member.
I tried to make that same argument when I was saying this is where some of the most important advocacy is happening, and that, you know, being organized at the state level has never been more important. So to me, from some of my closing thoughts here, some things I've jotted down throughout the day, some of the themes that I've heard, I wrote down and circled the word expectations. And, you know, we touched on this a couple of times, but as I said, we dug ourselves into this hole largely by how we branded ourselves and how we've educated or misinformed the public in some cases. And, you know, there was a great question earlier today about what can we do? How can we start to operationalize some of this? And I advise that we take a long view about this, that this isn't something we're going to change immediately, but we can do it at the local level, in the community level, by, like I said, reframing how it is we brand ourselves and how we talk about what it is we do. So if you go to your township commissioners or city council or borough council or whatever it is, once a month or once a quarter, and you report on your activity, maybe you're a city government agency, township service, maybe you just serve these areas as a nonprofit or as an authority, and you report back to these stakeholders, change the conversation on what you report. Most of them don't demand your response time reports. We just give them that because they can understand it. Report on clinical metrics. Last month, we got 98% of our STEMI patients to a STEMI center within 25 minutes, whatever it is, right? Reframe that into clinical quality. We properly identified pre-hospital stroke scores and got patients to stroke centers. These are the clinical metrics that we've done. So now stakeholders and the public know that it's the quality of care we provide that matters and not necessarily the speed with which we got there to provide it. All of that. Steve talked about expectations for workforce too, right? Where there's expectation and reality, the gap is frustration, right? If it's, we're going to train you how to save lives and, snatch, life from the jaws of death and all this, high drama stuff. It's not what the job is. We didn't prepare them to hold somebody's hand because they're scared, right? If the expectations are reprogrammed, both for our workforce and for our communities, we can start to make that impact. So that was one of the themes that I thought would be good to revisit here as we close. Another one is to make the case, and it's tied to this, that what we do is clinical health care, not public safety, not, we may be part of public safety if we're part of a fire department or a community response system or whatever it is, but we are healthcare clinicians, whether we are fire-based, private company-based, nonprofit, hospital-based, and to act as, to brand ourselves as, to hold ourselves out as, and to reinforce ourselves as healthcare clinicians is important. I tend to get so granular about that I think how we look to the public plays a big part of that. In some of the EMS system design templates we've written in that looking like a cop is not an acceptable way to present your healthcare clinicians because of the lack of trust people have when somebody with a badge shows up and we're asking them, how did this happen? What happened here today, right? If somebody got into trouble through drugs or if it was violence or even if that person does not have legal residency status, they may be reluctant to call 911 and to utilize health care, right? So our place is not law enforcement. And Dr. Kupas, who was mentioned a few times here today, who was one of our presenters last year, had a phrase that I love, and that is that a lot of times we try to look tactical, right, in EMS. And I think the more we look like law enforcement, the more we do a disservice to population health, to be quite honest with you. So we visited on that theme a little bit last year in our medical civil rights discussion, but being seen as and paid as healthcare clinicians separate from transport, I think, is a case we have to continue to make.
scrubs. I say we all wear scrubs.
Well, maybe something a little more protection, but you're on the right track.
Tactical scrubs.
There you go. Okay. And then nomenclature, right? Just this idea of how the public sees us, how elected officials see us, how payers see us, how stakeholders see us, from emergency medical services to mobile health care and community-based health care delivery. We are in the population health business, whether you think you are or not. That is the business we find ourselves in. And how we brand that, yes, these sound like, well, what's in a name? Well, perception is in a name. And if we can rebrand and reshape the public's perception, that will directly impact sustainability, right? And the joke that I made earlier is if we jump out of a nondescript white minivan with a smock and a stethoscope hanging around our neck, the perception will be, wow, a doctor came to my door and it only took 2 hours, versus you got lights and sirens on your ambulance and it took you 15 minutes. What the hell took you so long? All of that is based on public perception. So it's just a name and it's nomenclature, but it does impact delivery of service and it impacts sustainability. So those are my closing thoughts. And Dean Cummings, I will turn it to you to close. Don't want to do this without recognizing again Professor Johnson, Corinna Wilson, and Dean Cummings for the amazing support for this program year in and year out. So thank you to our panelists and our presenters, and Dean, it is all yours. So thank you.
I think it's been an invigorating day. I learned something new and important every single time I sit in one of these sessions. I wanted to end with my gratitude. First, my gratitude to you all that do the EMS work. I'm grateful. I'm very grateful to Doug Wolfberg and to Paige Wolfberg and Worth and to Steve Worth and to all of the folks from the firm. Thank you so much for your support. One of the things that I try to do as dean of this fantastic law school is I try to bring meaningful content to our space. And I can't think of more meaningful content than this, what we did today. EMS, services, and I learned a lot today. I learned my favorite phrase may be as tight as the hinges on the gates of hell. So I'm gonna use that term for my 23-year-old kid because he must be related to Worth's kid. But even more than that, I learned about perception, and I learned about how much you all care about this work that you do and how meaningful it is to the communities that you serve. And I'm so grateful that you care about these things. I'm so grateful you cared about EMS and civil rights last year. I'm so grateful that you care about regulation and perception this year. These things are super meaningful. So, if my goal as dean is to bring important content into this space, then mission accomplished today. So thank you very much. Appreciate it. Christian, did you have any closing thoughts? Thank you all for being here. You're welcome here anytime in the Douglas M. Wolfberg courtroom at Widener University Commonwealth Law School. Thank you.